Good morning, Counsel.
Good morning, Your Honors. May it please the Court, I'm Attorney Kenneth Quat. I'm here on behalf of the plaintiff in this action, Diane Golchin. With me at counsel table is co-counsel Attorney Elliot Barrison. This case arises from the defendant's denial of Ms. Golchin's claim for MedPay benefits under her auto policy. The bills for which Ms. Golchin sought payment had been covered by her health insurer, Blue Cross and Blue Shield. The Superior Court judge dismissed her complaint solely because, in his view, MedPay was not required to pay bills that had already been covered by health insurance. The appeals court affirmed on this basis and also cited as
They
reason.
didn't really affirm on that basis, did they? Didn't they affirm on the basis that you hadn't supplied, your client hadn't supplied the health insurance policy?
That was one of the bases, correct, Your Honor. But the appeals court cited, I think, three reasons. One, that we didn't provide the policy. One, that the bills had been covered. And one, that the defendant was entitled to rely on Chapter 90, Section 34A. It was the court's first reason cited in the opinion.
Because I thought they said they didn't even need to reach some of these other issues.
Right, and if I could address that, Your Honor. First of all, as a threshold matter, the defendant never requested the policy. The only place in the record where the issue of the policy appears is in a letter to Attorney Barrison.
No, yeah.
Okay.
But just why, since it became such an issue, was there a reason that you didn't want to give over the policy?
It was never an issue prior to suit. That's the only place it was mentioned, and it was in passing, and it was not a request. And let me address also why it's completely irrelevant to this case.
I understand why you say it's irrelevant.
Right.
All right, but I don't mean to stop you. Go right ahead.
Well, no, because
Is there any reason why there can't be double coverage, payment of double benefits in this case?
why there can't be?
Yeah.
Not that I'm aware of, Your Honor.
Okay. So in your view, the plaintiff can recover both from Liberty Mutual and from her health insurer?
Absolutely, under these circumstances.
Is there any reason, assuming that to be the case, is there any reason why the Commissioner of Insurance and/or insurers couldn't amend the policy insofar as it's dealing with medical payments, the provisions, Section 6 or whatever it is, that's dealing with medical payments to add as one of the coordination of benefit pieces that if you get your insurers, if you have health insurance covering these things, MedPay isn't going to pay?
Since MedPay isn't statutory,
Right.
but is nonetheless regulated by the Division of Insurance, I suppose the policy could be amended after the insurer goes through the proper administrative regulatory channels. But clearly the policy as written provides for...
Right, that's your point. But
Right.
It's not like it has to be that way is what I'm asking. I mean, there's nothing in the statute that requires this.
There's nothing statutory that requires it.
Is there anything in MedPay that suggests that it's not a primary policy?
No.
Is there anything?
I'm sorry, Your
excuse
Honor. Only in the limited case of coordination of benefits between 2 and 8, where
2 and 8 PIP.
2 and 8 PIP. Yes, Your Honor.
I'm sorry. Go ahead. No, go ahead.
Go ahead.
No.
What do you do? What do you say with regard to footnote 10 in Metropolitan Property, which says that we agree with the appeals court in the Mejia case that after collecting $2,000 in medical coverage under PIP, an insured must submit further medical bills to his or her health insurance provider for potential coverage, and then if the health insurer denies coverage, the insured may then submit the bills to the insurer for consideration under PIP. And then if PIP is unavailable, then you get MedPay. Haven't we at some level already decided against you in footnote 10 of Metropolitan?
Your Honor, I would say not, and the reason there are two reasons. Footnote 10 talks about the procedures for coordinating benefits, and we don't dispute that those procedures are well established in the Commissioner's regulation and as confirmed by this Court. By statute, PIP is mandatory and exclusive between 0 and 2. Then between 2 and 8, health insurance comes first. If there's a denial, the bills then can go to PIP. Go to PIP, or if there's a deferral clause in the health insurance contract, directly to MedPay. I believe that's all that footnote 10 reflects. And keep in mind, too, that we're talking about a situation here where bills had been denied by health insurance, not paid by health insurance. So those are the two distinctions.
And
But, I'm sorry, go ahead.
following from that, the 2008 insurance bulletin,
Yes.
I take it your position, I mean, I think even clearer than footnote 10, certainly implicit in it is a view that you only get med pay in this circumstance if if the health insurer has denied. But your point would be, even if that's true, there's nothing in the statute or certainly in the policy that justifies that.
Our position is that if health insurance denies between 2 and 8, and keep in mind, of course, that Ms. Golchin is beyond 8. She was never in a category of having to deal with coordination of benefits. But nonetheless, this case raises the question. But between 2 and 8, if health insurance denies, then PIP becomes the next resort, unless, of course, there's deferral language.
Right.
Our position is that if health insurance pays between 2 and 8, MedPay is co-primary.
Right, and you would, and with respect to the 2008 bulletin, you would just say it just doesn't deal with this
It doesn't address that, similar to the footnote. It's not the same situation.
But, I'm sorry.
No, go ahead.
You're saying, though, that, let's assume, I forget the numbers here, that there were $100,000 worth of medical expenses, all of them paid by health insurance.
Correct.
And you're saying that your client would get the $2,000 for PIP
Yes.
and then would get the full med pay.
Our client actually received the full $8,000 in PIP, most of which were lost wages,
Okay.
and then
but-
would also be entitled to the full MedPay benefit based on the reasonable value of the services.
So, but even if there were no lost wages, and even you would say that it's not the 2 to 8 that you get because you got health insurance. You wouldn't get that, correct? Or you wouldn't get the PIP for 2 to 8 because you were covered by health insurance, and in my example, you had no wages under PIP.
That's
But
correct.
you still get the med pay.
That's correct.
So why would you need then to wait to see what the health insurer did under your theory? Because it would be irrelevant what the health insurer did. You'd still get your full med pay regardless.
Once the $8,000 in PIP has been reached, Your Honor, quite honestly, we wouldn't have to wait. We could go directly to MedPay.
Except you can't under the way, I mean,
Oh.
regulatorily, can you?
Only up to 8 we can't.
Yeah. The
I see.
211 CMR Section 38.05 says that a plan that does not include a coordination of benefits provision may not take the benefits of another plan into account when it determines its benefits. Does MedPay have any coordination of benefits in its language?
The only relevant provision in MedPay
Is the PIP?
It cannot duplicate PIP payments.
There's another one
Is
for
the
other-
Bulletin 2008-12, is that inconsistent with Code of Massachusetts regulations?
I don't believe so, Your Honor. If you could point me specifically to the concern, I can try to...
It says that, the Bulletin says that where a claimant has both health and med pay, she must submit her claims to the health insurance carrier first.
Correct. Between 2 and 8, in terms of setting up the coordination of benefits and the procedures, it must go to health insurance first. This is in Section 34A of the no-fault statute.
Okay.
Then PIP has a shot at it unless there's been deferment,
Okay.
which is the Metropolitan case.
Do you take issue with the appeals court's statement that Golchin is not entitled to collect twice for the same bills?
No. I mean, do we take issue with it? Yes, we do. Absolutely. I mean, MedPay is a co-primary plan of insurance. It was a separately bargained for and contracted for and paid for coverage, just like another life insurance policy would be or disability policy, and is under, as defined by the regulations. It pays irrespective of other plans, again, except in the limited circumstance of when PIP is between 2 and 8. And again, Ms. Golchin was not in that category.
Now, why is it not reasonable to say that it is secondary because MedPay clearly can't be paid when there is still PIP available, correct?
No, that's not correct, Your Honor. MedPay can be paid when PIP's available. There are circumstances under which PIP will not cover a particular bill.
Okay, right.
And MedPay might come in.
But if PIP will pay it, you don't get both PIP and MedPay.
That is correct.
And
That's right.
And I gather that the insurer's argument here is, well, you can interpret the language to say that because PIP will not double pay when there's health insurance, that you said that implicit in it being secondary to PIP is that it's also secondary to health insurance. And that's my sense of what their argument would be.
Right. I realize that that's at least part of what they're saying, and I also realize that that's directly contradicted by the insurance regulations and by the decisions of this court.
Which decisions of this court
Well,
you say directly
Metropolitan and Bierce, in which this court held very clearly that MedPay is primary, except in the very limited situation of coordination of benefits, where in some circumstances it may not be.
Well, it said it appears to be primary in Metropolitan.
Well,
But I agree with you that Bierce, it is somewhat contrary to Bierce, and I think, the whole idea of primary and secondary comes out of the insurance regs.
right.
And I think the insurance department basically interprets it to be primary.
Right, and we know from the information submitted by one of the amici in this case, Academy of Trial Attorneys, that even the insurance industry has viewed it that way, going back to at least 2003, and we would submit much further back than that, where they realized that MedPay can result in what, and often does result in what they refer to, unfortunately, as double dipping. Double dipping we think is a very unfortunate word, since there was a separate premium paid and a contract is, but nonetheless, that's how it's been viewed traditionally, and they recognize that if there's going to be any change, that's going to have to come either from the legislature or from the Division of Insurance.
As a matter of public policy, when you think about coordinating benefits, doesn't that cut against allowing for what you're arguing here today?
Well, I'm not sure what you mean, Your Honor, respectfully.
Double dipping.
Well, I don't want to use
Well,
that phrase.
Well,
You just said it was a bad phrase.
It
so.
doesn't affect anything pertaining to a public policy of cost control, for example, if that's what Your Honor is concerned about with insurance premiums, because that cost control that concept has only applied to compulsory insurance, such as PIP and bodily injury. MedPay is completely optional, additional insurance for where a separate premium is charged. There are no cost control aspects to that. Another way to look at it is that
It's paid for.
it's-
It's like going out and getting 10 different life insurance policies on your own life.
absolutely, and then having one of the insurers coming back and say, "Wait a second, your life wasn't worth as much as we thought it was. Can you please give us back the money, or we're not going to pay you."
But the
That's exactly
pragmatic,
what it is.
but the pragmatic consequence, if you prevail, will be that there will likely be an increase in that premium for MedPay in order to accommodate the increased coverage, and that for those who simply want to get paid where the health insurance will not cover it, they actually won't have any particular means to do that more reasonably.
Your Honor, I would disagree with that, because, as I indicated, the issue that arose here has not arisen until relatively recently. In fact, this case might be the first time. Traditionally,
And why is that? I mean, it's not as, everybody has most everybody now has health insurance, so why would this issue not come up a lot?
well, because quite honestly, Your Honor, this is the first time that we're aware of that any auto insurer in Massachusetts has taken the position that Liberty has taken in this case. Traditionally, MedPay has always reimbursed for bills paid by health insurance, and that's the primary reason being the policy language. There's no exclusion for that, but it serves a significant benefit for policyholders to reimburse for lien payments, as what happened in this case. And it actually keeps health insurance costs down by facilitating the repayment of health insurance liens. So if we talk about cost control, it's actually the plaintiff's position in terms of a public policy matter that would have the largest positive consequences.
Counsel, your time is up. Thank you.
Well, just about. Thank you very much.
Good morning, Your Honors. May it please the Court, my name is Miles McDonough. With me is Christopher Riley. We represent Liberty Mutual, and we seek affirmance of the judgment below. I'd like to just quickly touch on the public policy issue that was just being discussed and then work back to the other questions the Court has raised. On public policy, I would commend the amicus brief of the AIB to the Court. It explains how coordination of benefits affects loss control, affects policy rates. So there is a very, very real money issue going on here in terms of what rates
Are you suggesting then that the policy rates now contemplate that you won't be paying in these circumstances?
I think the policy rates are adjusted from year to year based upon loss experience. And right now, according to the 2008 bulletin, I want to get to Justice Spotswood and Justice Gaines' question on that in a moment, that's the status quo, or at least it is what people presumably are following. The coordination of benefits and whatever loss control arises from that should be what the rates should reflect as time goes by. But the nub of this appeal is, I submit, touched upon in the invitation.
But just getting back to that previous point, is the position that you're advocating inconsistent with the practice that has been taking place for the last, say, 10 years?
If you know.
Not if people are following Mejia and Met.
No, but I mean, just as a practical matter, do you know what insurers other than your client have been doing? Is that what your question is?
Yeah.
Yeah.
I would presume they're following Mejia. I believe they're following.
So the position that you're advocating is essentially an expression of the practice that has been taking place over the last, say, 10 years?
I would expect so, Your Honor. I don't have the empirical data other than what we see in the AIB amicus brief, but Mejia held what it held. The 2008 bulletin is consistent with that, as are the regs. So presumably that is what's going on. It's what's going on, obviously, in this case. If I may, I think that really the nub of the appeal is the question posed in the invitation to amici. That is, heads or tails, yes or no, did the commissioner have the authority, statutory authority, to do what then she did in 2008 with the issuance of the bulletin? And the answer to that is yes. And
based on what? I mean, if you I don't think you have to interpret it, but if you interpret it to the way you want to, which is it's a negative pregnant, that if health insurance is there, you don't get med pay.
Right, Your Honor. It is a very explicitly laid out mechanical step that takes you to the result that you have to do that. You have to present to the health carrier, get the denial letter, and then present to the auditor.
Yes, but it's not dealing, it's coming out of a case in which there was a deferral policy. So that's what I mean about negative pregnant.
I understand, Your Honor. And there is a distinction, obviously, between a deferral situation and a situation where we can't get the policy to see whether there is or is not deferral in it.
Well, presumably there wasn't because they paid them.
Exactly,
So let's just go from there. Let's go from there.
And here we go with the statutory authority. There's a laundry list of statutes at the bottom of the regulations. What I want to do to assist the Court is run through and give you a handful of explicit citations that will take you right to the heart of the authority. For example, one is Chapter 175, Section 4, Paragraph 3. That is the paragraph that authorizes the Commissioner of Insurance to examine what it is insurance companies do out there in the real world in managing insurance. 175, Section 4.3 states that the insurance commissioner shall consider the National Association of Insurance Commissioner Handbook criteria. Page 519 of the handbook actually states, with respect to examination of health insurers, that the examiner is to look at as a reference point the NAIC coordination of bulletins regulation that we've discussed at length in the brief, that is the model and is adopted in Massachusetts. So we have a mandate to the Commissioner of Insurance that coordination of benefits vis-a-vis health insurance regulation is the rule. In addition, I'm sorry, I'm just going to say.
You finished. I shouldn't have interrupted.
That's all right, Your Honor. In addition, I was going to say, in addition to that mandate, that statute goes on to say that the commissioner can engage in or come up with other procedures as he or she deems appropriate. So you have right there an example of an ability to regulate vis-a-vis health insurance that's expressed from the legislature. Also, Chapter 175, Section 110E, paragraphs D and E, gives explicit regulatory authority to the Commissioner to regulate the substance of health insurance policies. Chapter 175, Section 175E2, that Justice Spotsford referred to in the Met opinion, refers to regulation of MedPay rates. As the AIB amicus brief explains, coordination of benefits affects loss history, affects rates. Chapter 175, Section 113B is, paragraph 21, is an explicit delegation of regulatory authority concerning regulation over compulsory, which includes PIP, and loss, and paragraph 1 of that section specifically deals with cost control. So you have all these different elements that are being talked about in this coordination of benefits situation here, where there's explicit regulatory authority issued from the legislature to deal with coordination of benefits.
Yeah, but you have one fundamental problem, which is that if I am a person buying auto insurance and deciding whether or not I should pay the extra premium for MedPay, I look at the provisions you have, and there's nothing that says that it is secondary to health insurance, even though you quite clearly say that the PIP is secondary to health insurance. So is it fair to a consumer who's paying this extra optional premium to be purchasing MedPay when you have not made explicit to them that we're not going to cover for expenses which are covered by health insurance?
Well, I think it's fair, Your Honor, because all expenses are going to be paid for under the coordination scheme, number one. Number two, and this goes back to some questioning the Court had earlier on the primary versus secondary issue, if you will. When we interpret contracts in Massachusetts, we do so with the underlying statutory and case law in mind. That's the old Mayor of Salem case, and numerous cases of this Court have held that. Here we have, as Your Honor, Justice Gantz repeatedly was trying to raise in the earlier presentation, PIP clearly does, the relationship between MedPay and PIP clearly is primary PIP excess MedPay. Section 34A, in the non-deferral context, the context we did not have in Metropolitan, plays a key role here because it's statutory and it's grafted, the contract has to be, it subsumes it. So what you have is, the net result is, you have, because of 34A, that puts the health insurance primary, and then you have PIP above that as a secondary role, and here the MedPay is, in a sense, a tertiary kind of coverage. It's clearly at least secondary, but even then some. So the way it all works is, as explained most efficiently in the 2008 bulletin, it's really a very wonderful synthesis of how to work the problem.
But nobody purchasing auto insurance is going to be referring to the Commissioner's bulletin for guidance as to what it means. I mean, how hard would it be to say, we will not cover you for expenses paid by health insurance, which, after all, 96% of people in Massachusetts have. I mean, it's not an unexpected consequence here that you'll have health insurance which may cover these expenses.
Well, just to put it another way, all the statutory authority that you've been referring to may give the Commissioner just the authority you're talking about, but the fact is the standard policy at the moment doesn't do it, which is what Justice Gantz is saying.
No, I understand, and what I'm saying is, number one, it does when we interpret the policy according to Mayor of Salem and graft the law into the policy. That is what it is.
But that's not really fair, is it? Because MedPay is not a statutory policy.
Right.
It's just a
no. But
the language of the policy is determined by the intent of the policy. The interpretation of the policy is determined by the language of the policy, not by the statute.
Well, by the language of the policy incorporating the provisions of the statute. That's how you get the end result of how it works. Now, I understand the point that's being raised here, but the second point that I would raise in response is the question is, yes or no, is there a violation of authority in the Commissioner? The end result here, as I was saying, is that there is a most efficient, cost-effective spreading of available resources. That's the point in the AIB amicus memorandum. Rates get reflected by loss experience, which is affected by coordination of benefits. When you do not duplicate, then you end up with a more efficient situation. Rates get lower, and that's a good thing. I submit to you, Your Honor, the Commissioner is well within the explicit statutory authority and as a matter of fairness here, because that's what's happening. The efficiency is being maximized on the available coverage.
Well,
There
how is
is
it being
value-
maximized when everybody in the state of Massachusetts has to buy medical insurance, and they can't make a decision about whether to buy medical insurance, but they can make a decision as to whether or not to buy MedPay?
The result, there's a value to the MedPay, Your Honor. There's a clear, it's not,
What's the value?
the value is, well, it's the Dominguez situation, where somebody goes outside of the medical plan, violates the terms of the medical plan. That's where MedPay kicks in to help. PIP, also it has a similar function to PIP. If you have a deductible or a copay, and you have $100,000 in medicals, as you go up the wall, think of a brick wall, so to speak, and you run into a copay for $25 here, or $15 there, or $50 here and there, that is where PIP comes in to fill the mortar as you go. And PIP is a relatively small amount of money, as typically is MedPay. That's why they're small. And they come in, and when the PIP gets eroded, then the MedPay starts to get eroded, so that people don't have to pay, even though they have co-pays and deductibles that may first arise after their, or may continue to arise until they're $50,000, $60,000 into medical bills, but they're still getting coverage because it's spread out. That's the value of it. That's why there's nothing unfair about this. Everything about it is fair. By the way, the 2008 bulletin here, I just want to explain that it arose out of a followed Metropolitan to clarify things. One of the problems that was happening following Metropolitan was that the MedPay carriers were being put in a bit of a box by claimants who were not willing to give or not willing to come forward and provide information about the nature of their health coverage. So MedPay carriers ended up being put in a little bit of a, sort of a Abbott and Costello who's on first situation, where the question was, is the health carrier primary or secondary? The dilemma was that if the health carrier was primary and the MedPay carrier was secondary, then you can't pay without violating Section 3807 of the regs. Conversely, if the health carrier is secondary and if the MedPay carrier is primary and the MedPay carrier goes ahead and pays, then the MedPay carrier ends up getting penalized with a double payment if the health carrier, the secondary health carrier, comes along later and says, you know what, we shouldn't have paid them, but you shouldn't have either, and the regs let us collect from you. So there's a bind, that an untenable dilemma that the claimant put Liberty Mutual in here, and the answer to that is what the Commissioner came up with in the 2008 bulletin. It's self-executing. What the Commissioner says is, the Commissioner puts the burden where it's supposed to be on every insurance coverage issue. To get coverage under any kind of policy, it's always been the law in Massachusetts and everywhere else in the country that the insured has the burden of coming forward and showing that there's coverage. And in order to do that here, the mechanics are that now it's explicit in the 2008 bulletin, if you want to collect on MedPay, here are the steps you go through. And it's the presentment to the health carrier, et cetera.
Why is the answer to your argument not that it's a perfectly sensible proposal that you're making, and you can do it, but do it clearly enough that the consumer knows what they're buying? I mean, if you lose here, there's nothing that bars Liberty Mutual tomorrow from revising its policy and saying, we will only cover, MedPay now only covers expenses above and beyond your health insurance.
Well, I guess,
and it's useful to you because sometimes if you go out of coverage with regard to your health care provider, they may not pay you the entire amount. So this will mean that if you go to a chiropractor or an acupuncturist because of an injury, you'll still be covered. But we're not going to cover you for expenses that are covered by health insurance.
well, Your Honor, I mean, people can always go back and revisit and reword things, but what I'm saying on this case right now, this is a very fair result with superb public policy ramifications with regard to the way it's handled under the 2008 bulletin. And if I may, just one other point here as to the intent, and going back to the question that was raised in the notice for amicus briefs, the question of authority. If the 2008 bulletin holds, and it's consistent with the regulations, and there's no dispute here that it is, we heard that during the plaintiff's presentation, then this issue is resolved. This case is resolved in favor of Liberty Mutual because the plain language of the bulletin does, in fact, continuously provide that there is that burden of presentment to avoid double payment, double dipping, duplication, whatever you want to call it. As I said earlier, our reg is based on the NAIC reg. The NAIC reg's commentaries are in accord with the 2008 bulletin. It states, page 138 of our record appendix.
It's in your brief, right?
No, it's in the appendix, Your Honor. The aim is to make sure that the combined payments of all plans do not add up to more than your covered health care expenses. That's page 138 of our brief.
Could I just ask, if I could just ask you one general question?
Yes, Your Honor.
If the policy, because this is part of the standard policy, correct?
It is, Your Honor.
Is there, does it have to be? In other words, just to follow up on Justice Gantz's questions, if Liberty Mutual wanted to amend the provisions of its policies vis-a-vis just MedPay, obviously you can't do the rest of it, but just MedPay, or maybe you can, could you do that? Or would you have to get the Commissioner's approval?
Oh, I think they'd have to go for approval, but we're dealing with a Commissioner now who has issued a bulletin that makes sense, and obviously the Commissioner feels that it's a very appropriate way to handle the matters. I see, Your Honors, my time is up. I thank you, and otherwise refer you to the briefs.
Thank you, Counsel.